Good morning and welcome to the David and David on Real Estate podcast. And today we have a very special episode. David Corman, a lot of my agents ask me for the episodes where we analyze different law statutes and we really peel back the layers and get into it. They love listening to this content. So why not bring them more of that? We have you in the house with your expertise. So we are on episode number 97 today. And today we're going to talk about some legal precedent cases.
Yeah, and it's, as a lawyer, I always find it funny. Like every once in a while, we have to look at the law and the legal cases to remind ourselves of why we do things. And as you know, I'm not a litigation lawyer. I'm a there's barristers and there's solicitors, and I've never been a barrister. I'm a solicitor. We do transactions, and every once in a while, we sort of forget why we do transactions a certain way and why what the general principles behind that are. And this is how we remind ourselves. And as the cases come through and get decided, that's what we're relying on. So it's like I'm not sitting here looking up law all the time, and neither are you. But occasionally, we have issues on our files, and we've got to, well, why is it like this? So that's something we're going to discuss today, because in today's market, David, as you know, like every transaction that we try to close is a bit of a challenge. There's issues that come up, and people are taking positions because things aren't necessarily closing on time, and people need extensions, and they have to negotiate for those things. So it brings up all these principles, like the parties have rights to do that, and so that's where these cases come into play. So I think it's every once in a while it's good to have this pause and try and figure out how we deal with these situations.
Yeah, and what's really interesting, what I love about the law, David, is that as these cases go through the court systems and as judges, rule and issue their judgments, and as those judgments are pushed to higher courts, to the appellate courts, and to the superior court, that's when really the law starts to shape. And by going through this process, we get something called precedent, which is great because it kind of reshapes or redefines or readjusts the course of how all of us have to interpret some of these laws, and it really shapes how we transact on an everyday basis.
Right, and this case that we're going to talk about now, which we refer to as the Bhasin case, it's Bhasin, Bhasin, and Hyrnew. It's a decision that was, I don't know, it was 10, 12, 14 years ago, or maybe longer. I forgot already. And it had nothing to do with real estate, but it was a decision that discussed some basic contractual principles of whether parties can act on their strict rights under their contract, or do they have an additional duty to act honestly or in good faith when they're dealing with another party. So this case had nothing to do with a real estate transaction, but the principles and the discussion in the case are important and have everything to do with the way we deal with our real estate transactions. Okay, because in this case, it was, if I remember correctly, it was a distributorship agreement between one party A and party B that had a renewal rights, and in the course of there was an automatic renewal, or each party can give notice to terminate, for whatever reason. And it automatically renewed. And then there were some disputes going on in their relationship, and there was a forced audit upon them by the Securities Commission. And, one party sort of forced appointed a competitor to do the audit, which would, put that one party in jeopardy of certain information being disclosed. So they sort of balked at that idea. And there was just sort of this breakdown in relationship. And that led to one party saying, okay, I'm not renewing. And that's what the case came about. Now, they had a clear contractual right to not renew. There was nothing in the contracts that they had to renew. Either party can give notice that they're not renewing. But because there was some underlying facts going on there and some bad faith between the parties and the way they were dealing with each other during the course of the contract, this went to the court to determine whether or not they were acting in good faith and whether they could exercise that right to terminate. So it had nothing to do with real estate, but it led to this whole discussion of, do the parties have a duty to act with each other honestly and in good faith? Okay, which is no different than in our real estate transactions. We start with our printed form agreements of purchase and sale in a standard residential transaction or in a commercial transaction. The rights of the parties are clearly set out in writing, you hope, clearly drafted. But can the parties strictly rely on what's written in there, or based on the facts that happened between the parties, can an argument be made that, hey, you weren't acting in good faith with me? So even though you have strict rights, there was something dishonest about your activity, or you weren't acting properly, or you were deceptive. Therefore, you can't rely on what the contract says.
Yeah, very interesting. And I guess this decision went all the way to the Supreme Court of Canada. So it went through all the different court systems. And my understanding, David, and I'm not a lawyer, but the way that I interpret this case is that prior to this decision being rendered by the Supreme Court of Canada, that when you entered a contract, you could choose not to perform the contract and pay damages, right? That was a choice that you had. So you could perform the contract, or you can choose not to perform the contract, knowing that if you don't perform the contract, you can pay the damages and go on your way. But I think in my interpretation, the Supreme Court of Canada said, well, no, when you enter a contract, you really have the principle of good faith to complete that contract. And you need to complete that contract. And it's no longer acceptable not to complete the contract and simply pay damages as a way out of the contract.
Yeah, and those are correct legal principles, David. And I know you always, I'm not a lawyer, but I play a lawyer in a podcast. And I feel the same way sometimes as a litigation lawyer, because I'm not a litigation lawyer. But I think that's correct. Like, if you don't perform your contract, general principle, no surprise to anybody, you'll be responsible for damages that accrue. So that's the basic remedy for people that don't perform their contract that they're going to be facing. But there is another remedy that's available sometimes, and this comes to play in real estate transactions, and that's the remedy of specific performance, where someone's going to court and saying, no, I'm not, just giving me damages isn't good enough. There was something about that property that I want the judge to order that this transaction be completed, because I can't be compensated adequately just by damages, by monetary funds. And it's a tougher argument to get that remedy, because you usually have to satisfy a judge that there's something special about that particular property. It's not just, a standard house in the middle of a subdivision. If you don't close on that one, you can go next door and buy the next property, which is very similar. So, because if that's the case, if those are the facts, the judge is not going to give you specific performance. They're just going to make sure you're compensated in damages. But sometimes there's something unique about the transaction or about a particular property, or why they want that property, and can't be satisfied by just getting another property. And a judge can give that type of order too. So anybody that's thinking they might default and just face damages has to know that there is this potential remedy against them of specific performance as well.
Yeah, this leads me back to, I think, one of our very first podcasts that we ever did, because we spoke about breach of contract, right? What happens when the transaction doesn't close, and we talked about specific performance. And I guess my question, David, is, now that the Supreme Court of Canada kind of rendered this decision back in 2014, is it easier to get specific performance? Because we always say that, it's harder, the property has to be more specific. But now, if we know that a contract that's entered into has to be completed, and you can no longer take the position that, hey, I'm going to choose not to complete this contract and simply pay damages. Now, when the Supreme Court of Canada basically said, hey, now you have a duty to really complete and act in good faith, is it going to be easier to get the specific performance judgment? Are we going to see more of that in the court cases?
Well, I think in theory that makes sense, okay? Because this concept of acting in good faith has become more and more prominent. Now, you got to remember there has to be facts in the particular situation to show that someone was not acting in good faith. Okay.
Right.
So just because someone breaches a contract doesn't mean they're necessarily acting in bad faith. If they're just, going in the normal course of the transaction and not acting dishonestly or doing anything, that may not come into play. But let's assume that there are some facts that give rise to that argument acting in good faith. So then conceptually, there should be more orders of specific performance. Okay. The problem is it's a tough remedy. And the reason is, you know how long the court process generally takes in a normal, like if you're just suing for damages, your day in court might be a year and a half, 2 years from now till it goes through the system. Okay. And there's no real peril to the parties to it because at the end of the day, they'll get compensated in damages by an award, which will include interest and costs and things like that. It can all be addressed. Okay. But there's always a timing issue. But if you're going for trying to get specific performance, you have to get in court right away because you have to get a judge to give an order preventing the seller from selling to anybody else. And there's some time constraints on it because the parties are ready to move, they're ready to close, the closing is supposed to be imminent, or maybe the closing had already happened, so they can't wait around for 2 years and keep the property in limbo for that. So you have to go to court right away. So in order to do that, it's a really expensive process. Okay, you got a litigation lawyer. He's got to, get a date in court, convince sometimes to get an order to stop the transaction or make an order so they can't sell to somebody else. Because if the transaction didn't close, the seller is going to normally take the position, hey, we didn't close, you didn't close, you're in breach, someone's in breach, we're going to sell to somebody else, we're relisting it. So now someone's got to get to court and put a stop to that. Say, no, I need an order from a judge really quickly to stop them from selling to somebody else because we want to have our day in court to argue for specific performance. And then you've got to bring that on a rush basis. So you've got to be able to convince the judge to give you the order to stop selling to anybody else and get an order to have this set down so that you can argue in court for specific performance. And then you've got to put your materials together. You got to give it to the other side. There could be an examination, discoveries on the material. So even on a rush basis, there's a lot of work that has to be done. It's extremely expensive. So you're paying a litigation lawyer an awful lot of money up front to try and go for this. And that lawyer is going to do some sort of analysis of, what are your chances of getting this? Can we get this? So it's not easy. Okay. It's not an easy remedy to go up. So yes, it's a little long-winded answer, but in theory, there should be more of this. But the
Yeah.
practicalities of going to get it and getting in and out of court and the expense and the risk of not getting it is really high. So that makes people pause, right? Because, people, if you think you're a buyer that really wants this property, your deposit money is already tied up. Do you have deep pockets to start litigation on that level to get into court quickly to get that order? That's and
Yeah, David, we lost you there for a second, but I completely agree. I think that we're seeing a lot of these court cases go through the court systems right now, and we're seeing the courts consistently uphold the contract and find the buyers that have been in breach by not closing the transaction liable for damages. So I think the good news is that if you go through the court system, the courts have consistently upheld that the breaching party is in breach of the contract and have awarded a lot of damages to that party. So I think that actually acts as an estoppel and a deterrent for people to not act in good faith and not fulfill their contractual obligations. So I think the system's working, and I think the courts have consistently shown that they're going to rule in favor of the injured party and uphold these agreements. And we're going to have to wait and see what happens. But I think in the future, we're going to see more of these cases go through the court system. And I'd like to see them, be reviewed faster. I think if the courts are ruling in favor of the injured party, I think there's going to be less people not fulfilling their contractual obligations. We're going to see less of these cases go through courts because buyers are going to understand that if they don't close, if they don't fulfill the contract, the contract, there's going to be dire consequences. And then hopefully we see more time being alleviated and these cases going through the court system a little bit faster. And I'd like to see more specific performance remedies being implemented to the court system, just to really show that if you enter a contract, you have the good faith obligation to complete that contract, and giving the power to the injured party to make sure that contract is completed. Thank you for joining us. This has been a great episode. We lost David Korman there at the end due to a back connection, but everybody, thank you so much, and join us next week as we continue diving deep into other legal precedents.